Okay, welcome. This is Arizona Court of Appeals Division 1, cause number CA-TX140005, Hub versus Maricopa County slash ADEOR. Welcome. For the parties' information, these proceedings are being recorded both audibly and visually. Hopefully in due course you'll be able to see yourselves on YouTube. As you approach the podium, please identify yourself and who you are representing. Each side will have 20 minutes for their argument. Appellates, you may reserve a portion of your time for rebuttal. And if you'll tell us how much of rebuttal time you want, we'll try not to horn in on your time. We have read the briefs, looked at relevant parts of the records, discussed the case in conference this morning. So we are aware of the facts and the issues that are before us. The podium will tell you how much time you have in front of you, including your rebuttal time. So with that, you may begin.
Thank you, Your Honor. Good morning. For the record, my name is Paul Mooney. I'm here with Jim Wright. We're here on behalf of the plaintiff and appellant, Hub Properties Trust. And it looks like our outgoing lawyer left some papers here, so I'll hand those to Mr. Wright. He may discover he's missing those at some point, but the issue before the court this morning is whether Arizona counties can assess property taxes against property in the absence of any legislative enactment of authority to do so. That is undeniably what happened in this case, because the county imposed a tax that was based on a change in ownership on property that, as of not only the valuation dates and the tax lien dates, but as of the relevant assessment period, was owned by a governmental entity and was therefore not subject to tax. The county in its brief has made much of the argument that somehow this case is about an exemption from tax. It is not. This case has nothing to do with exemption from tax, nor has my client ever claimed an exemption from tax. It has nothing to do with property escaping tax either. What it has to do with instead is what the Arizona legislature has prescribed as the mode, manner, method of assessing property within its province under Article 9, Section 11 of the Arizona Constitution. The legislature, under the Constitution, is required to determine the manner, mode, and method of assessing all property, and that is exclusively a legislative function.
Well, why was it? Well, then, if it seems to me that there is a method by which this property was assessed, was valued and assessed. Now, granted, at the time it was valued, it was not owned, and it was an exempt piece of property. But when it was assessed by the Board of Supervisors, it was indeed it did belong to your clients, and there is a method by which to do it. It seems to me the only thing you could be arguing is if by not paying it or not being liable for the taxes is you have to be claiming some kind of an exemption. And you've just said it's not an exemption case. So how do you get around the fact that there is a method by which property is assessed, property is valued, property is assessed? That was done in this case. And your client, and there is no statute. I think both parties agree that there is no statute to prorate the taxes. So how can you say it's not an exemption? There is a method to do all this.
Well, there is a distinction, and it's well recognized under multiple Arizona cases that there is a difference between property being taxed and property being taxable or subject to tax. And in fact, this court in Airport Properties went to some lengths to describe that constitutional history, in particular as it relates to Article 9, Section 2, which is the exemptions clause of the Constitution. And interestingly, in that case, they said essentially the same thing you just did to me, Your Honor, which is, this is quoting from Airport Properties, "We are confident that as the county contends, the present statutory machinery is fully adequate for valuing, assessing, equalizing, and collecting taxes imposed on possessory interests in governmental real property." But notwithstanding that, the court said, you can't do it because there is no legislative delegation of authority to impose such a tax. The fact that they determined a value that was frankly never placed on the tax roll, was never used as a basis for assessing any taxes, as nearly as anybody can determine according to the record, doesn't mean that they had a lawful basis to then assess and levy a tax against this property. That is a separate question from whether or not they had the ability to determine a value. And no, my client is not asking for an exemption from tax. In fact, my client's asking for the exact same treatment that every other taxpayer in Maricopa County and the state of Arizona is entitled to, which is to be valued and taxed in accordance with the provisions of the statutes. If this was new construction, they wouldn't have been assessed till tax year 12. If this was personal property that wasn't in place on January 1, it wouldn't have been assessed until 2012. If it was construction work in process, it wouldn't have been assessed until 2012. If this was an error correction claim, we would have to look at the situation as of the valuation date, which was January 1 of 2010 in this case. So you have a situation here where the statutes cover a wide range of things, but they don't cover this situation. In fact, the two Attorney General's opinions that they attached to the end of their answering brief in this case I found very interesting. I went back and read Mr. Pickrell's two old Attorney General's opinions from the 60s, and in both of them he states there is simply no authority under Arizona law to prorate taxes. Well, to properly assess this property, because on the lien date it was owned by the government, the county would have had to prorate the taxes. There's no question if they'd tried to send a tax bill to the city of Phoenix for the entire year or any part of it, that tax bill would have been unlawful and invalid under Article 9, Section 2. No question at all. And yet, they've now sent me a tax bill as the new owner of the property who acquired it on March 4th, 2011, and said, you're liable for the tax for the entire calendar year. Well, what they can't do to the city, they certainly can't do to us. There's no authority for them assessing the period from January 1 to March 4th. What if that date had been August the 4th? Still would have been prior to the levy date. Under their argument, it would have been all fair game and would have been all taxable. But if that's going to happen, we should ask the legislature to pass a law to do it. It's not hard. The legislature's already written statutes in Title 42 for prorating taxes when property is destroyed. They know how to write it. They just didn't write it for this, and they've never written it. And they haven't written it since the 60s when those Attorney General opinions were written.
Well, but isn't the statute that allows them to collect taxes on any commercial property that allows them to collect the 2012 property taxes against HUB. Why isn't that the statute that should be applied?
Because there's a fundamental difference in that case. In that situation, there is a comprehensive statutory scheme in place by which the county establishes a value, notifies the taxpayer of that value, sets up appeals rights, there's a procedure for equalizing taxes, all before taxes are levied. And it's very interesting.
I understand that, but you also have a situation where as a new owner, you do get the right to come in and
after the fact, you're right.
After the fact, but still, you do get the right. You do have the right, and I believe you even did in this case.
We did.
Come in and dispute the value, dispute the amount, and you even got it lowered. And so, I guess my concern is I just don't see any difference in the statutory scheme that allows the county to collect the taxes of 2012 than it did in 2011. Now, granted, I agree. The fact that there is no prorating is kind of makes people who buy exempt property from governmental agencies it's too bad, but that's not something that we can do anything about. I think that's something that the legislature has to deal with.
Well, we're not the ones here arguing for a proration of tax. It's the county that, if it was going to impose a constitutionally proper tax in this case, for tax year 11, not 12. Nobody's quibbling about 12. We're not arguing about whether we were subject to tax in 12, whether we had remedies to challenge our values, even though we didn't get those notices. All of that was taken care of through a statutory scheme that we invoked and took advantage of. And in fact, the county, even in its own parcel history database, says property subject to tax in 12. We're going to change it for 12. Interestingly, there's nothing in the county's parcel history database that ever suggests that we're going to impose taxes for 11. The first notice that my client received that a tax bill was being sent for 11 was when they got a tax bill out of the complete blue. And there was no opportunity to challenge that value. There was no opportunity to do anything about that valuation.
But there is an opportunity. It's after the fact, but there is an opportunity to do that.
Not for 11.
For 11, you did. You
No.
challenged it, and after the fact, but you did challenge it, and you got it reduced.
Yes, after the fact, which of course the Supreme Court says is not the standard. I mean, in fairness, I'm not here making a due process argument that my client was somehow denied due process of law ultimately. Substantively, they were able to get notice and a hearing. But it wasn't because of anything in the statutory scheme that happened. It was because the county acted illegally, ultra vires. They issued a tax bill without any statutory authority to do so. And they sent it to my client. And my client had to pay the tax to challenge, to have even the right to challenge the tax, which doesn't comport with what the Supreme Court said is the mandate under Trustees Lodge. But there's an interesting aspect to this case.
Would it be different, Mr. Mooney, if in fact the county had listed the taxes on the tax roll, even though the city wasn't paying it?
If the values had been placed upon the tax roll, it would have made a difference because then it would have had an impact on the tax levy. The statute that levies taxes in Arizona, ARS 42-17-051, and this is not mentioned anywhere in the briefs, because it didn't even occur to me until this morning as I was rereading all this, that, wait a minute, they levied a tax based on a rate that was computed on the basis of property that was subject to tax in 11. 17051A3 says, in calculating the levy, the Board of Supervisors shall determine the assessed value for the current tax year of all property in the political subdivision that was subject to tax in the preceding tax year. So the tax levy that they imposed on this property was based on a calculation that did not include the assessed value of this property. Now, the way that formula works, since the assessed value is in the denominator of the tax rate fraction that you compute each year, they effectively increased the rate that would otherwise have been applicable to my client's property. Because if you increase the denominator of a fraction, you reduce the rate. And so it may have only been, minuscule amount in a county of this size where there's this much assessed value wealth, but the simple fact is the legislative scheme contemplates that you will set the rate based on what's assessable, what's subject to tax. So the rate that was set in tax year 2011 that was applied to my client's property without color of authority under the law was based on a calculation that excluded my client's property. Why? Because it was not subject to tax in the preceding tax year. That's no different than new construction. It's no different than personal property. If I bring a huge piece of equipment, Intel's one of my clients. Let's say they bring in a $120 million piece of equipment to make computer parts, and they bring it in on January 2nd. Guess what? It doesn't get taxed until the next tax year. Why? Because it wasn't there on the tax date, on the tax lien date. The county doesn't dispute that proposition. Nobody disputes it. How is that any less fair to the system? The fact is the legislature is delegated the exclusive authority under our Constitution to determine that, not just what is subject to tax, but when it is subject to tax. And this case is simply a question of when is it subject to tax. We're not arguing about whether it's subject to tax. We're arguing about when it's subject to tax. And that is the issue before the court in this case. And the county jumped the gun. They assessed a tax before they could. No different than if they had tried to do that with personal property that Intel brought into the state on January 2nd. No different than if they tried to do it to new construction. It's contrary to law. And the law is clear. I mean, the airport properties case, I mean, I frankly love the quote from Airport Properties because to me it encapsulates this whole thing. And ironically, Airport Properties was a case involving the GIPLET. The government property lease excise tax was enacted to replace the possessory interest tax that was the focus of airport properties. So after the legislature passes the GIPLET, creates this mechanism, the county says, wait a minute, we can still go out and assess leasehold interest in government-owned property. And here's the court's decision. We offer a brief comment on the county's universal mandatory property taxation thesis as measured by the yardstick of common sense. The succinct response is found in the following cogent observation by the court in Fox Riverside. Quote, there are many classes of taxation which the state may provide for but does not. Close quote. I would simply change that quote slightly to say this in this case. There are many types of property which the court, there are many classes of property which the state could provide for the taxation of this year, but which it does not, because that is in fact the case here. I'd like to save my remaining time, if I may, for rebuttal, unless the court has other questions right now.
No, thank you.
Thank you, Your Honor.
Good morning, Your Honors. Kathleen Patterson from the Maricopa County Attorney's Office on behalf of Maricopa County, the appellee and defendant in this case. Putting aside what I plan to talk about, I'm going to talk about what y'all were talking about just a moment ago. We started off with the questions about whether there is a method. The county's short version of what we did, what we think that is absolutely legal, was follow the statutes, follow the statutes, and follow the statutes. It begins with the assessor is obligated by statute to list all real property. It says, the statute says, regardless of ownership and regardless of whether it's exempt or not exempt, it's on the list. And it's on that list by, according to the statute, in December 15, when the assessor has to come up with his first list. This for 2011, then that would be 2009 that this property was listed. It was valued according to the principles of valuation of all real property like it. Its current use is office buildings, a retail center, and a movie theater and the surrounding parking. There's not one bit of evidence in this case that suggests that the assessors or the county has not historically taxed that kind of property, office buildings and retail centers or a combination thereof throughout Maricopa County. So there is a method in place. It was followed down to the letter. There was no new construction throughout the 2010, what's called the valuation year, and therefore nothing changed. Come 2011, which is the tax year, the fact that we have computers now can pick up almost instantaneously when title changes. The assessor only has to enter a code to say it's exempt or remove the exemption code. When this occurred in April, I'm concerned that counsel has said a couple of times in his brief and then again here that this property was never on the tax roll. It was always on the assessment roll. The question of assessment and valuation is the process that gets you to the tax. The statutes then that apply to taxation are those that deal with the Board of Supervisors and what they are required to do, and that is in the third Monday of August in 2011. It says, the statutory language specifically says that shall tax all taxable property, which Hubnell admits it was. Its property is taxable. It is not exempt. The statute also says that the board then levies the tax, and that document constitutes the assessment and tax roll for the year.
So when it was assessed for its full cash value in 2010,
Yes, Your Honor.
okay, it's on a tax roll that a computer base that someone can find?
Yes. Yes, and there's some references in some of the cases to the fact now, and I think there's statutory authority that was applicable in 2011, that the all data regarding the assessor's values listed property values are now available on the public website. We have that ability, and that is, in fact, using the technology of the day, anybody can find out anybody else's values and assess values. So we have.
Was that true then prior to the date that Hub purchased the property?
Yes. Oh, yes. I don't know that this is in the record, so I'm now testifying, but it is the website has been in place.
We can check that. We can check that record.
The website has been in place. Before websites, though, the way to find out information was the old telephone. Call the treasurer's office, call the assessor's office, and that information had to be publicly made available to anybody who was interested in knowing the value of property and the assessed values that would affect taxes in the following year. This is spread out over a period of time now, of course, starts in like 2009 and ends up in 2011. But the point is that when the county got the assessor's list of properties and then says, now we have to figure out levies and levy the tax, this property was on it. The statute required that the board to then tax it, and then the bills went out to the owners of record when it was taxed. So everybody in Maricopa County who owned it, a day, a year, 100 years, whoever owned it on that day, all get their tax bill for that year, whether they owned it a short period or a long period of time. And they're all obligated. We know that the custom, of course, is to prorate in practice, and the buyers and sellers do that. But there is no statute that says that any of these participants in the market have a right to proration. I have, from the county's point of view, when you get a tax bill, what Hub is saying, wipe it out, and we're saying we have no authority to take that bill from you or anybody else who wants a proration because there is no statute.
So I just want to ask you again, I know that Judge Portley just asked you, but it was something that Mr. Mahoney said regarding that this property was on the tax rolls. Is that correct?
Yes, and here's what we probably do this as much in practice.
Because there's an assessment.
Yes.
Even though you're not going to send a bill to the city.
Right. The process, we probably use tax roll consistently. The statutes talk about assessment roll, and then they talk about assessment and tax roll. But it's who's doing what that matters. The assessor doesn't tax. The assessor only assesses value. So by any name, what all the things that the assessor does is an assessment of value. What the board does is assess tax, and that's at the end of the process. So we sometimes use assessment and have to think, which one are we talking about here? At the moment, we're talking about it in the sequence of events. The assessor is doing valuation.
Okay, so in 2010, the property was listed, even though it belonged to the city.
Correct.
The property was listed, it was valued, but it just wasn't taxed until the property changed hands.
In this, what I understand is a very complicated tax system we have in Arizona. In 2010, the relevant taxation event would have been for tax year 2010.
Right.
So yes, the city would not have been taxed for 2010 during that year. That year's also the valuation year for the coming year. So there's more than one thing going on here at a time. So it was exempt from all the taxes that had been levied prior to 2010 and prior at all times that the city owned it. When the event of transferring it, and the city transferred it to other buyers who transferred it to Hub, it entered into the private ownership where it became taxable. That taxing event, where we say, is the third Monday in August event. And there was nothing illegal about taxing Hub's property, which is the only property in this case. All the conversation about exemption is about somebody else's property. So to talk about Hub's property is to talk about taxable property. There was, unless I didn't answer you, there was one other.
So if I'm just a nosy neighbor, sometime after, either before or after March of 2011, I could have gone onto the website, looked at the properties, and found the assessor's value.
Yes, and if you were a buyer, certainly
I'm just nosy, regardless of whether I'm a buyer, I just want to, what the heck's going on down there, and what are they doing, and what's the Bob worth and everything else.
Right.
I should be able to find it on the assessor's
That's correct. And I'm sorry I interrupted. Yes, as a nosy neighbor with no interest in the transactions that are going on, you could find out. If you're interested in buying and selling property, yes, you and your real estate agent, your broker, and everybody on the planet will be looking for that information. That's part of the transactional process of finding out what is owed, utilities and everything else included, not just taxes. There's
This is work backwards. If the state or if a governmental entity would buy private property on the sale date, would it become exempt and no taxes are due at that point?
It's an equal proposition. The county does not have jurisdiction to tax government property, period. So as soon as it enters the roll before a tax levy, all the taxes are wiped out. We can't tax it. There is one case I cited in there in a bankruptcy situation where a government entity acquired it after the levy. The trustee in bankruptcy acquired it with the lien because the tax had attached. So, but before the levy, it works both ways. And no taxes are taxed if it's, and with computerization, it's my understanding, up to the minute. We can say it became state property the day before the levy. It's state property, and we can enter that in a computer now. Some of the cases here go back to 1905 and 1940s, and I don't think that the same situation can be said, and there may have been practical problems that had to be resolved. But with the computers, we can pick up that data, or should, we have that capacity, and then put things on the roll that should be, include them, in the tax roll, what the board sees, or remove them if they become government property. Yes.
Ms. Patterson, Mr. Mahoney has said over and over again that there is no statutory scheme that allows the county to levy taxes in this case for the tax year 2011.
What I'm hearing isn't that there's no scheme for valuing office buildings, retail shops, and a movie theater, we value the fee simple interest in real property. The statutes I was talking about earlier are talking about the valuation of real property. And I've read airport properties, of course, more than once and garnered this glimpse out of the case that I think I should share. It says that in that case, of course, it was involving possessory interest, not fee simple interest in real property. The court said possessory interests are a discrete category of property in and of themselves. The relevant inquiry in that case is the legislative intent to tax despite the repeal of that tax. This has nothing to do with this case, in the sense that we're talking about comparing the nature of property as office buildings, real property, and a fee simple interest, and the intangible properties, the stocks, the bonds, and whether there's a scheme for those or not, is not answering the question that's presented here. Can we and did we validly tax real property and the fee simple interest in that real property that has been historically always valued and on the list, like office buildings and so forth? Yes. The argument they're making is that there's no proration, and we agree, but we say the county then can't give you anything because there's no statute. And it's our position that there is no constitutional right of a private owner to get proration. I've also offered a little piece of thought in this, in my analysis in the brief, that nor should there be. If you look at the one instance that the legislature has addressed proration, the topic in the property tax code, it prorated value, not taxes. And it did so in the situation where property is destroyed after it's already on the roll, but before it's taxed. And it said that you divide then prorate the part of the time where it was the original value against the part of the time that it's destroyed, because its value is obviously reduced. The real disconnect, and I believe in the party's arguments here, is the ownership of the estate as a governmental entity didn't impact anything about valuing business, business offices or the retail center and so forth. So ownership isn't affecting the value There's no evidence that they have claimed any issues with the valuation. We've resolved the amount of the value is now over $160 million, and the question is whether they have to pay tax on the value that is agreed to. If I haven't answered everything, I may have another thought here. We had talked a little bit, you asked questions about due process. I think our brief covers these issues. The plaintiff, or Hub, is not mentioning, in fact, there was a new owner statute under which they have the rights that are given. There's nothing to suggest, and I haven't had a chance, haven't had anything really to respond to, because there's no cases cited, they're not citing anything that establishes why isn't that sufficient due process. The double taxation.
So really, if Hub had waited until the day after the Board of Supervisors did the valuation, they would only be looking at 2012?
The 2011, right, there'd been no taxes levied because it was still on the tax roll. What the board got, the list the board got says it's city property, no tax. Actually, the computer looks at it, but you know what I'm saying. It's not on the roll, it would not have been taxed. So that, yes, and I can only imagine.
It was on the roll, but it was on the roll as exempt.
Correct.
Okay,
There
thank
you
you.
go. These are codes that get switched now,
I
and the
understand.
code was always office building, commercial property is one of the part of the code, but the additional code is whether it is municipal property or not municipal property. That was removed. That's the other thing that I've seen. The only affidavit evidence in this case was presented by the county. The county's affidavit from one of its assessors who actually made the entry in the log that Mr. Mooney was talking about under oath, talks about the date exactly when it was changed, and that is April of 2011 after the change in ownership. It was not first changed for 2012, or we wouldn't be here talking about this. It was changed for 2011 by that entry where the code was removed. Mr. Mooney has talked about statute on assessing a value that's subject to tax, and a statute that we didn't brief or we didn't talk about. I think that it would help to know or understand in this entire process for the subject tax year we're talking about, the roll, the list of property. There are constant changes before up to and to the day of taxation. For example, changes of ownership can now be entered into the record. Judgments are entered for reductions in value or changes in classification for prior years that may affect 11. Those are entered. It's almost to say it's a work in progress, because we can now pick up these things that legally happen throughout the year. None of those happen to the subject property, but it is a work in progress. And so I don't recall the statute, but I know that it's about the levy limit, and the board is always informed about how much is exempt and how much is not exempt. So whatever they're considering, I think there's, I don't know what the word would be, a fudge factor. They have to recognize that there are going to be changes made, and particularly one like this one that is required by operation of law. This isn't something the county decided to do. This is something that just happened. If the government entity acquires it, it's done. And if they sell it, it's done. The exemption is gone. So in the conclusion, we see everything. Oh, sorry, Judge, you look like you have a question.
Well, and I think that's Mr. Mooney's point, that at the time of value, it was owned by the county, and so, excuse me, the city.
Mm-hmm.
And so when it was time, and the city was exempt.
Mm-hmm.
And so there's not, other than the fact that you know, and you can follow what happens with sales, there's not a statute that suggests that once the value happens, once there's been a change of ownership, there's supposed to be a relook.
It's supposed to be a what, sorry?
Some sort of, I don't know.
Revaluation?
Revaluation.
That comes from the incorrect premise that this was not valued to begin with.
Okay.
Nothing changed. The fact that there was an exemption has to do with city's rights or its entitlement. It has nothing to do with valuation, because we're still talking about the same Arizona Center. That didn't change. ownership is not a part of the valuation process. So it's not like more value or less value because of ownership. And so all the rules about changing the value so that these taxes is on something different don't apply in this situation. Nothing changed. The Arizona Center was valued as such. It was taxed as such. Whether there were 10 owners or 2 or anything else, that process is consistent to the end. We also feel that still mentioning that the property was exempt on valuation date or any other dates is still a city issue. City isn't complaining that there's a right to be free from valuation. They're not here, and they're not claiming that, and nor is that, would we contend if they were, we would respond that that's not.
They don't care.
They don't care. They got their money and they ran.
No, they don't care. They don't care because they're exempt.
Well, they got their money out of the property. They don't know what.
That's
Right.
that's a different story, but they don't care what you would assess the property for because they were exempt.
That's right.
Whether it was a penny or a bazillion dollars.
Right, and we think that the county has a legitimate interest in keeping track of properties because they do move in and out of ownership during the period of time, and we have to track that. And like this one, it became taxable. So it wasn't added to the tax roll per se. It was always on the list. But to the extent that what the board created is called a tax roll, then yes, it is on the tax roll at the point that it is taxable. We think the case law supports what we're saying. The old cases have to be interpreted, of course, with a little different view because they're likely didn't have this, or they weren't. The cases that I read did not refer to the fact that exempt property was included on the original roll and ownership was not relevant. That's a difference in facts between older cases and today's cases. So we ask that the judgment of the court be sustained. Thank you.
Thank you, Ms. Patterson. Mr. Mahoney?
I've got to clear up a couple things. There's some terminology that's being used very loosely here, and it isn't accurate. First thing Ms. Patterson said in her argument was that the assessor has to do this. Well, what the assessor has to do is prescribed by 42-15054B. The assessor shall make such investigation as necessary to ensure that all property subject to taxation in the county is properly included on the assessor's property lists. So yes, she's right. You'll go if you're nosy and you want to look up and see what the value of the Bob is, or whatever they call it now, or the America West Arena, which is what I still call it. If you want to go look and see what those are, yeah, you can look them up. You know what? You can also look up what the value of Camelback Road is. The county puts a value on every square inch of the mapped boundaries of the county. So what? That property's all exempt. Nobody cares what those values are. They don't go on the tax roll. They do not go on the tax roll. The tax roll is maintained by the treasurer. The treasurer is the one who issues tax bills based on what's on the tax roll. This
After the supervisors does their.
correct. After they set a levy that's based on a rate that's calculated based in part on the assessed value of property that was taxable in the prior year. This property wasn't on that, so the rates were not set with that in mind. So that's simply not true. The only legal authority which the county cited in its brief or below to support what it did here was the City of Phoenix versus Elias case. That was the sole authority relied on by Judge Fink in his decision in the tax court. Elias does not support what the county did here. It simply does not. Elias was a situation where somebody bought some tax lien certificates. They bought them on January 3rd. 2 days after the lien date because they were in the state's ownership. And so they thought, we're going to get exempt for the whole year because the state owned the property on January 1. And all the court said was, interestingly, if it is conveyed to a private party between the first Monday in January and the first day of May, which was the assessing period at that time, it will be subject to taxes for that particular year. Well, what's intriguing, of course, is a lot's changed since 1946 when Elias was decided, not the least of which is the entire assessment calendar that we're dealing with. Everything is now assessed 1 full year in advance. The roll closes on December 1st. You know why that is? That very statute that you construed in Forum Development that talks about all those changes was because, in part, the government wanted to be able to know when they were setting tax rates what the rate should be They didn't want to constantly be guessing. So the roll closed a full year before those rates are even set. That was a big part of Senate Bill 1362, which was the changes that changed this whole scheme in 1995. So the fact of the matter is, any of the cases, the condemnation cases, and they're all condemnation cases, by the way, and most of them involve cases where the government acquired property that had previously been taxable. And all the case law says is, nope, the government's exempt, so you can't tax that stuff if they acquired it. That makes perfect sense. Why? We already know there's a tax bill. We already know what it is. It was set in the ordinary course in those cases. What we don't know, and what none of those cases ever state, because nobody can cite to it, is that there is any provision for the converse. Why might that be? Every one of those cases talks about something that occurred during the assessing period or prior to that. In that case, it's fair to assess the taxpayer. Why? Because we have a process. We don't have that process here. We simply don't. Now, in airport properties, it's interesting. This court said something very telling. And Ms. Patterson quoted it just a moment ago in part, but she didn't quote the whole quote. This is from paragraph 43 of the airport properties decision. Viewed in that way, a legislative decision not to provide for ad valorem taxation of possessory interests does not, quote, exempt, close quote, them from taxation at all. Possessory interests are a discrete category of property in and of themselves. The legislative decision does not exempt them. It omits them from the state's exercise of its power to tax by dint of sovereign political discretion. It is undisputed. I could cite you a dozen cases that say this. The power to levy a tax is never implied, but must be directly and specifically granted. Supreme Court of Arizona. Another one. The power of taxation under the Constitution inheres in the sovereignty of the state and may only be exercised by the legislature. The legislature never acted here. I see I'm out of time. I will shut up. Thank you for paying attention, and we appreciate your consideration of the case.
Thank you so much for the argument. It's been very helpful. And we are going to take a brief recess, let the new case come up, and so we will recess briefly. We'll be back.